because for a long time, I think people thought the state's going to solve my problems. And I think we're getting to a point now where people are thinking, well, civil society is going to solve my problems. But in truth, you are supposed to be the first person trying to solve your problems, even if they are massive. Take hands with your community, take hands with your neighbors, and try and solve those issues. And yeah, I mean, that's really the best way to try and build a better South Africa, I'd say.
How effective is legal activism? Well, joining me on the show is Danil Eloff. He is an attorney with Herta Spies Attorneys, and he is joining me on the show today to discuss public interest litigation, of which he has extensive experience, especially for somebody as young as himself. Danil Eloff, welcome to the show.
Thank you, David. It's lovely being here.
So, Danil, you've had quite extensive experience with public interest litigation. You've been involved in a number of cases, specifically during the lockdown, and we'll talk about those in just a moment. But maybe let's start off with what drew you to the profession of law? What got you interested in becoming a legal practitioner?
So I think I was rather lucky, because when I was still in high school, I was sort of contemplating whether to go study politics or law. And I sort of had to, try and figure out which one to go with. And in the end of the day, I thought that I can always enter politics while having a law degree, but I would not be able to sort of join the legal fraternity if I have a political degree. So that got me into the law, and I started studying law. But I was rather fortunate to be able to start my legal career at a firm that's already, involved in civil rights litigation and public interest litigation. I mean, you'd really only have a handful of firms in the entire country that do this type of work. And I was very fortunate to start at a firm and do my articles of clerkship at a firm that was already, busy doing this type of litigation. So I'd like to believe there's, a bigger hand over this entire process. And yeah, I've been really great, fortunate, and I'm grateful that this is sort of the path that's led me here. And I think I am quite lucky to, at this young age, already be involved in these type of cases. A lot of times these are the sort of cases which go to the Constitutional Court, which not a lot of litigators get to actually, experience the Constitutional Court, let alone doing that on, a frequent basis as we do at our firm.
Oh, well, that's the opposite story to me, because I was originally registered for an LLB at UCT and went down, and after my first year of humanities studies, I said to my parents, no, this is the kind of stuff that I want to do. Ended up doing my master's in politics. So, but here we are. All right. Well, for those people who may not be legal wonks, such as yourself, what do we mean by this concept of public interest litigation? How is that different from normal commercial litigation, for example?
Litigation. Yeah, I mean, it's a good question. I actually did a postgraduate course at WITS a couple of years ago regarding public interest litigation. And I've sort of grappled with what exactly it is, because if you look at the academic literature, public interest litigation has sort of been dominated as, I don't want to call it a left-wing tool, but it's rather been focused on, it's been utilized by sort of left-wing causes. In the 1960s and 70s in the United States, you saw a lot of advocacy groups use public interest litigation for civil rights movements, equality movements, etc. So traditionally, it's really been, used as a political tool on the left. Although I think in recent years, and at least in the last decade and maybe decade and a half, it really has been, a lot of more sort of conservative and libertarian-minded organizations have started using public interest litigation to achieve their political goals. I mean, in one way, you could probably describe public interest litigation as a sort of, political lawfare, although I tend to feel it's, where it's just another forum, and I've mentioned this on previous interviews, and I think also previously to you, is that a court case is just another forum for the battle of ideas. It's just another battleground where you fight this battle of ideas. And for a long time, only one side was fighting on this battleground, and now you sort of have more parties involved. So I do view it as a positive thing. I don't believe in South Africa, we're not really a litigious country, generally speaking, at least compared to the States. But I do believe we we do try and resolve conflicts through our courts, right? That's why our court rolls are so overburdened and so busy, is because people do revert to the courts to try and settle disputes. And I see that as a positive thing. It's a civilized way of trying to resolve disputes. I mean, the opposite of going to courts, I think, is much worse than trying to resolve your issues in a courtroom with robes and the civility of court decorum. So perhaps getting back to sort of your initial question on public interest litigation, I would say that basically it's litigating on behalf of various interest groups and trying to protect their particular rights, or at least their interpretation of their rights. And that's what it boils down to in the end of the day.
Yeah, in some ways, it's a bit of a misnomer to call it public interest, because there is no such thing as the public interest. There are many interests, plural,
Yes.
and they're competing for each other. And that is the nature of power and the contestation for political power as well. Also,
yes.
But I do think that the courts are a very critical arena in which to defend people's rights against the might of the state or another actor that might be infringing on their rights. And so I think that is really a critical space that you're operating in. Which brings me to my next question, which is, I mentioned your involvement in many of the areas of litigation around the lockdown. And that was a particularly unprecedented encroachment by the state on the rights and liberties of individuals. Obviously, it was a period of high degrees of uncertainty, particularly in the initial phase of the pandemic. But as the crisis kind of continued, we saw some quite aberrant interventions by the state that really had nothing to do with public health. So could you explain some of the major cases that you were involved in and some of the battles that you fought?
Yeah, I'm happy to sort of, I feel the list is endless. I mean, in lockdown for 2 years, we were really extremely busy. We where most businesses were, locked down for a prolonged time, we sort of got back after the 3-week initial hard lockdown. We were busy working because of, just the nature of our clients really compelled us to do so. I mean, one of the first lockdown case that we had was a group of South Africans who were quarantined in a quarantine camp in Limpopo. And they were kept in these horrible conditions, weren't allowed, to receive any medical treatment or packages from family members or food from family members. So we had to go to court urgently to assist them, and we were successful with that, which emboldened us. We thought, okay, well, great, the courts are, they're also scared about this lockdown thing. And initially we saw a couple of successes with lockdown litigation cases, not just at our firm itself, but, all over South Africa. We had that case, which was successful. We had another case on behalf of SAI, which is an agricultural network. And they assisted a bunch of farmers who wanted to export livestock, and they weren't allowed to do so. And we were successful on their behalf. There was another case on behalf of the school support center to reopen creches and preschools during the lockdown, which was also successful. So we sort of initially saw a bunch of success. And then there sort of came a dip towards the end of 2020 where a lot of these cases weren't successful. That's where we saw a bunch of people challenging the extension of the state of disaster, not succeeding. We saw a bunch of the cases regarding the regulations themselves, like the restrictions on movement, restriction on different sales of alcohol and tobacco, whatever, which weren't successful. And I sort of tried to figure out why this was, why, sort of only later in the year did we see this. And my theory is, well, the death toll really started to rise later in the year. And, judges are people and they have family members and they also read, the papers. And we started seeing the real effect of COVID on a bunch of people. And that sort of made them more hesitant to jump in and just tell the state, no, well, you're not allowed to do this. And that sort of continued for a while. And then later on, we started seeing a bit more of a balance on some of these judgments where the really obvious draconian measures were struck down, like the tobacco ban, while others weren't successful. And towards the tail end of this litigation, I also think the state got better at litigating. I think initially they were just completely overwhelmed. And later on, they sort of learned which fights to pick and which not to go, to oppose in the end of the day. And interestingly, the IRR did a PIA request to the Department of Justice and Constitutional Development, asking them for a list of all the lockdown cases that they defended. And in a bunch of them, they just simply didn't do anything. They didn't appoint advocates. They just said, oh, well, whatever the court decides, we'll be fine with that. But then there are certain ones where you can really see the state felt this is important. Then they, went guns blazing, appointed 1 or 2 or 3 advocates on their cases. So yeah, I mean, from our firm side, the cases that we were involved in, literally from that quarantine camp, the case, the case about the livestock, we were involved in the tobacco case, we were involved in some of the liquor cases. We were involved in the beach case, which we, in the middle of the holidays, tried to get the state to allow people to go on the beaches, and we weren't successful. And then everyone just ended up in the malls, which is still to today very strange to me. I'm baffled that we weren't successful with that case, to be honest. So yeah, I mean, we really did an entire litany of different lockdown litigation cases, and I'm very grateful that now, sort of 2.5 years afterwards, I can start doing other public interest cases and not just focus on all these lockdown cases.
I think it is an interesting example of that tension between the government and society and civil society actors, particularly NGOs that act on behalf of particular causes. And there is that tension. Myself and my colleagues often speak about the balance of forces theory, and often that involves the state advancing a particular policy or agenda, putting that on the table until it meets some kind of resistance. And it's important that you have organizations like the ones you represent forming that resistance. That is the process of democracy. Democracy is not only about the peaceful transfer of power at the ballot box. It's also about the day-to-day contestation of power in the public square. All right. So could you also speak to your role as an attorney? Because obviously you're working with advocates who are briefed by you. What is your role there? Are you just purely playing a supporting role? And how much are you getting involved in the actual strategic development of the positions of your clients as well?
Yes, it's also an interesting question. And in a way, it's a bit difficult for me to sort of compare myself to others, because I simply don't know. I haven't worked at another law firm, so I don't know how they do it. I sort of just know how we do it at this piece. And I mean, we're very much hands-on involved in the actual litigation and the strategy. So yes, we brief counsel to attend to a lot of these matters. I do a lot of appearances myself, which I was only able to do 3 years after being admitted as an attorney. Then I only got High Court right of appearance. But so I do enjoy doing that as well. But we do brief counsel in a lot of these cases, particularly cases which are rather high profile and you need a very senior advocate or advocates on the case. So sort of our role would be, I have weekly meetings with my clients, and we discuss various of these matters, and they have campaigns and they have certain issues and hot button topics that they want to touch. And then they come to us and they say, well, what can we do about this? Which is bit strange compared to the normal attorney-client relationship when, if it's, for example, commercial litigation or litigation on behalf of an individual. Usually when it's, normal, I would say 95% of attorney-client relationships work like this. The client comes to you, they say, listen, this company owes us money, or this company breached the contract. And you sort of already, they come to you with not the solution, but the solution is more clear. Right, where here a client would come and say, well, this is a political problem. How do we sort of approach this from a legal point of view? And often it's not, you don't have any legal remedies at your disposal. Often you can't really get involved, legally speaking, in a campaign, and then it's just purely a campaign for your client. But I mean, most of the time you try to find some sort of legal remedy, you discuss it, you debate it with your client, and then you also, at least my role in my practice is like that, is you sort of inform the client, well, yes, there is something to try and pursue here or not. And so it's sort of a first filter that you have. Your client has a bunch of ideas and you tell them, well, these ones are realistic and you can actually litigate on them. And then from there, usually the sort of the first initial correspondence that you send, It just comes from our office. And then you sort of, when you actually get to the point where now you have to go to court, then you usually brief an advocate, and you get involved with them. So in a way, attorneys are known for doing the admin work, sort of they're the contact between the client and they do the paperwork. And that's true in our instance as well, but we do a lot of the strategy work as well. And I mean, there are a lot of not court processes, but legal processes which aren't bound to the court. I mean, for example, a request for access to information, which we do dozens of at the same time. Those are processes where you don't brief counsel. I mean, you run with it and you go through the entire process because it's not a court process. So there's a lot of work, sort of the paperwork and grunt work that you do before you actually get to the point where you can litigate and go to court. So public interest lawyers, I would say, your relationship does differ quite a lot with your client compared to normal commercial type of work, but I quite enjoy that because so I would say my practice is about probably 75% is public interest litigation work for clients like AfriForum, DSA, Solidarity, PSI, Action Society, all these type of clients. But then the other 25% of my litigation work is just normal clients, businesses, individuals. And I think I appreciate the other 25% a lot more because the majority of the work is sort of really my passion and the work that I really enjoy. So I enjoy the change of scenery while doing the other work. Where I think if it were the other way around, I would have perhaps not enjoyed the normal work as much as I do at this point.
And what matters are you involved in at the moment that might be of interest to our audience?
So at the moment, we haven't actually recently been in court with any of these public interest cases. The last one we were involved in, and we're back in court early in November, is a case on behalf of Sunfield Home, which is an old age home in Mpumalanga. And they have had this situation where the Department of Social Development haven't been paying them increases for subsidies for all the people that are staying there on the states, the state have placed them there for that they're in a safe environment. And for like the past 20 years, the department hasn't raised their subsidies at all. And then at one point, they threatened to take away all of the subsidies. So we went to court to compel them to continue paying the subsidies while we then sort of negotiate regarding the increases. So that's one recent case that we're involved in. We're also at the moment involved in a case on behalf of Solidarity, the trade union, against the Department of Health. The Department of Health have decided to appoint a bunch of senior management employees for the National Health Insurance, which is quite peculiar because the NHI is not law yet. I mean, Parliament still needs to vote on the bill, but they're appointing people to work for the NHI. So it is a bit of a strange situation, and that case will be in court also early November, on the 8th of November. And sort of other cases that we're in the middle of is we're still in the middle of a case. We got an interdict against the South African government they've been donating money to the government of Cuba, which we then got an interdict restraining them from paying a further 50 million to the Cuban government. And that decision is now being reviewed, and we're sort of in the middle of that process at the moment. Perhaps another interesting case that I might mention is we're busy on behalf of PSI. We had a request for access to information sent to the Minister of Agricultural Rural Development to request a list of all the land claims that they have, because the minister, goes to Parliament and gives all these speeches saying we have X amount of land claims, but it fluctuates. It goes up and down, which is also quite weird. So we just asked, well, give us your list of all land claims, and they just refused. They didn't do anything. We went through an internal appeal process. They just refused to give anything, didn't respond to us. We went to court, didn't respond, got our court order, didn't respond. Only when we threatened with contempt of court proceedings against the minister, they finally, started doing something, when they were being threatened with being locked up. So that's sort of an ongoing case that we're busy with at the moment as well. And it's a rather important case because the land issue in South Africa is a sensitive issue, and we believe that it's sort of being used as a political toy in a sense. And it's really important that South Africans know, well, this is the amount of land claims that exist, and they need to be worked through. And we know how completely and utterly useless government's been with the entire land reform process. And now they're pushing ahead with, the EWC bill and a bunch of other nonsense, while they haven't even sorted out a process that started 20 years ago. So it is a rather crucial case to just, agree on which land claims have actually been lodged or not.
And do you think that there is potential for future public interest litigation around EWC? We now have the EWC bill before the National Council of Provinces. The Land Courts bill has also gone through the National Assembly. So, I mean, my understanding from the Glenister judgment all those years ago is that it's only until the bill is passed into law that you can challenge it constitutionally. But is there any prospect, do you think, of some sort of challenge like that in the future?
Probably. Well, I would not advise anyone to go to court prior to the bill actually being signed into law. It just wouldn't make sense. You can't get an interdict stopping government from legislating. But I mean, definitely, I know a bunch of organizations will litigate the moment the bill is actually passed, and we're probably going to see two types of cases. We'll probably see early cases of organizations going to court regarding constitutionality of the bill, saying, well, it's unconstitutional and it should therefore be declared unconstitutional and sent back to Parliament. Although I'm quite worried that would be the approach, because my concern is that the court will say, well, no, it's not unconstitutional, and we haven't seen any unconstitutional consequences of the bill, which would set a bad precedent. And then I think we're going to see a second wave of cases where people's property is actually expropriated, likely under dubious circumstances. And my concern is then that those cases are, jeopardized by the initial cases, which were almost academic in nature, right? And because it's going to be a rather academic question initially, it's only really going to become a live legal question the moment the government uses its new powers in terms of the act to expropriate without compensation, where the courts then have to grapple with the consequences of this legislation. So I think it's going to be interesting. I'm not as completely pessimistic as a lot of people regarding the bill. I think the bill in its entirety is horrible, but our courts generally tend to put the brakes on a lot of things, and I think that's what's going to happen with this bill. So yes, although the bill doesn't refer specifically to land, it refers to all property. I think what's going to end up happening is our courts will only interpret it as meaning land, and
there's no guarantee that they will.
No, not at all. I mean, I can be completely wrong. I think I'm optimistic, and I hope that's not what's going to happen. But I mean, the point is, the danger is that it doesn't read that way, right? The danger of the bill is it says property. It doesn't say just land. And when you tie this with something like the prescribed assets debate that we've had for a couple of years now, the government could say the same. They could say, well, okay, you have a bunch of savings. We're just going to expropriate that on the public good. Or they're going to say that about cars or, big company assets or whatever. So the danger is there. I just think, on sort of my view of the judiciary at the moment, is that's likely how they'll interpret it. I suspect. I'm not sure, but I do suspect that's probably what they'll do.
So, Daniel, I don't want you to impugn the integrity of the judiciary, but what do you think is the state of the judicial system at the moment?
I mean, it's such a big question, and I think my concern, my personal view, is our courts are good when it comes to questions which aren't sort of ideological or political in nature, right? It's just and equitable when it comes to sort of commercial matters, or when it comes to everyday type of things. My concern comes in when it's a very heavy political type of flavor to a case, and I have a concern that with those cases, they do tend to get rather partisan, or at least ideological. And I mean, it's probably not surprising. I mean, I mentioned this earlier this year at a meeting at my alma mater, but a law faculty tends to sort of be at the forefront of these ideological battles, and usually very much progressive and ahead of the rest of the university. Sort of postmodernist thinking, critical studies sort of first really take root at the law faculty, and then it sort of gradually moves over to all the other faculties, probably the humanities faculty and the law faculty. It starts there. But I tend to think law faculties even more than humanities faculties. And I think the same happens with our courts in a way, because the same, students of a couple of years ago who were at these universities being taught all of these critical studies end up becoming attorneys and judges and advocates. So I do think our courts, we don't in South Africa have this very partisan split between, clearly conservative judges and clearly progressive judges. In South Africa, I tend to think the majority of the judiciary really is part of the same broad political grouping. You obviously have strange anomalies like our former Chief Justice, who's now recently started his own political party, where he has sort of these schizophrenic views on a couple of things. He's, this fundamental Christian, but then on the other hand, he really does have a lot of progressive views, which is perhaps in some sort of political spectrums a bit bizarre, but potentially not. It probably depends on how you view the world. So
Daniel, do you think he's actually allowed to run for public office given his previous role as Chief Justice?
Yeah, it's interesting because if you read sort of the law black and white, then no, he's not. I guess the question just becomes if he's willing to give up his sort of the perks of being a retired judge. If he's able, to repudiate those perks and say, well, I no longer want it, whether he'll be permitted to do so. I mean, I should perhaps just point out that it's not the first time that we have a judge, although I think it's the first time we have a Chief Justice going to a political party, but it's not the first time that we'll have a judge in South African history that after sitting on the bench goes and enters politics. It happened before. It happened, I think, in the 1920s, and it happened in the 70s. So it's not strange. I think the strange thing here is it's an actual Chief Justice, and it's sort of the new constitutional dispensation. I think it would be a flippin' interesting court case regarding his personal limitation of rights, whether it's justifiable in an open and democratic and constitutional country to limit the rights of a former judge to form a political party or to be part of a political party. I mean, I think, yeah, that would be a flippin' interesting case, and I'd love to get involved with that if it ever gets to that point. Although I think we still should see how this is going to play out. I think it's sort of going to be a case where he's going to be the honorary chairperson of the political party, but not really involved, trying to walk this precarious line, try and justify his involvement. So yeah, I think it's going to be interesting.
Well, what about judicial appointments? Because we have the Judicial Services Committee or Commission, which is staffed mostly by politicians, national members of parliament, members of the provincial legislatures, and also the executive has some say there. There's the profession is also represented, the bar, the academia, but they seem to be outgunned by politicians. Do you think it's appropriate for us to give so much power to politicians to make judicial appointments?
Yeah, so I guess the question is what the alternative is, right? I mean, in the States, you have governors appointing state judges, and you have the president appointing federal judges, which perhaps there you could argue it's even worse because you just have one individual doing it, one politician. But I mean, in South Africa, it really does. I think it is a massive issue. We love to say we have this very clear separation of powers, but do we really, right? We have national elections. We vote for members of parliament. They determine who the executive. So the same people, one election determines the executive, and the very same parliament, in the end of the day, appoints judges. So how separate is it really? And I mean, that's why if you actually go and look into a lot of the background and histories of our judges, it won't be surprising to see a bunch of judges who 20 years ago were mayors of municipalities or heads of different state institutions or whatever. I mean, it does happen. That's sort of it's common practice in South Africa. And obviously, if they've been in political positions, they have a particular political affiliation, which at least in theory they've now had to again put a distance between them and their former affiliations. But I mean, in reality, if you it's the same with a sports team. If you're once a gunner, always a gunner type of thing, right? Are you really going to just
Never walk alone.
Yeah.
Yeah.
Yes, never walk
That's
alone.
what it
Exactly
was.
right. It's sort of it's part of you. So unless you really left the party on bad terms, you're still, going to be rather not necessarily biased, but you're going to be in support of that party and its policies. And we still have a situation where the ANC still are the national party and is still the national party in power at this point. And a lot of these judges, were formerly affiliated with the ANC. So, yeah, perhaps to get to your question, I think there's a lot of work to be done with reform on how we appoint our judges. I, for example, think a very proper and simple solution to just get a bit more of decentralization and a bit more of distance between the politicians, at least on a national level, and judges, would be, well, allow each province to appoint their own judges for their divisions, right? That would make a lot of sense, at least. It already decentralizes power. But, I think that's way too federalist for our current national government to even consider.
Well, I'm a big fan of federalism and devolution, so I would certainly support that initiative. And you mentioned the various regional courts. In the Western Cape High Court is really rocked by controversy with John Klope and lots of allegations flying around there, which I really don't think looks very good for the profession in that part of the country.
Yes, I mean, and now you sort of, again, you have this tension between a provincial government that really wants to push its agenda. And there've really been cases in the Western Cape High Court where you can clearly see that agenda of the DA government in the Western Cape being sort of blocked. Which, again, it's expected when you have a politicized bench, you're going to have sort of these politicized outcomes. So I mean, the Western Cape's a good example of it. And the problem is, judges can be shipped to the Western Cape because it's sort of it's determined on a national level, right? Had it been the case where the Western Cape had more autonomy, or every province had more autonomy to pick their, preferred judges, I think it changes the picture. I mean, it doesn't solve all problems, right? It doesn't take the politics out of it, but it like you says, it devolves power. And I think in the end of the day, it's a step in the right direction.
Do you think it's possible to have a completely depoliticized judicial system?
I don't think so personally. I mean, I always use the example that it's a person sitting there, on the bench. It's in the law we're taught about this, this objective, learned judge sitting on the bench, who's impartial and unbiased and just looks at the facts. But I mean, the point is, he's a person, he or she's a person. The person's flawed. The person has the own biases. And I think it's rather difficult. And probably that's why in South Africa we have the situation where when it comes to court cases which aren't politicized, we get decent judgments and it's fair and it's equitable. But the moment it becomes politicized, it's not as unbiased and impartial. But I guess the point is that likely like that all over the world. I mean, how else do you get judges who remain completely neutral, uninvolved in politics, don't read the news, aren't concerned about what government does? To me, it sort of seems impossible to achieve that. I don't know if you think it's possible to achieve an impartial bench.
Well, I think it's important that if there is some perception of a conflict of interest, that is declared, and that's incumbent on the judges to do that. So your example of a judge acting as a mayor, I seem to recall reading somewhere that the judge on the recent Kill the Boer case with AfriForum against Malema, that he actually served as a mayor of some rural municipality once. I would think that would preclude him from a case like this, so politicized. But I think to your earlier point, judges, they are operating within an ideological milieu. They are, often in South Africa, we'll see reference to transformation, the imperatives therein. But there's no mention of transformation in the Constitution. That's what Koos Malan, I think his name is, would refer to as transformania. There's this kind of political force that has basically made that a kind of a political norm or a cultural norm in the country. And judges are kind of operating within that context.
Yeah, I mean, Professor Malan, he actually makes this point, which is, I think, similar to the one I made earlier, where he says that our bench and judiciary, they're good on certain issues, but it's just so that they do that so that there's a wiggle room to sort of make these other atrocious judgments. He's a bit more pessimistic than I am, but so yeah, I mean, he quite actively says that they'll give on the sort of bit easier issues so that there's they can achieve what they want. But I mean, even with for example, one of the cases that I really despise, a constitutional court judgment, is the public protector case, where the court basically, it was in that entire debacle about Thuli Madonsela's report regarding Kandla, where she said, well, my report is binding, my findings are binding, and Zuma must pay back the money. And they went to court, went all the way to constitutional court, and the constitutional court said, yes, well, we agree, we're going to extend the powers of the public protector to make their findings binding. Now, a lot of people at the time praised that. They're like, yeah, it's great, awesome, now the public protector can do this. But little did they just think, literally a year in advance, when Thuli Madonsela's term came to an end, that we're not going to have a Thuli Madonsela forever. And now you have the situation where public protector has these expanded powers, much to, I think, the big regret of Cyril Ramaphosa at the moment. But and so it often happens where even cases where the majority of South Africa feels this is a good case or a good judgment, that when you actually just think about the practicalities and the consequences of the judgment, they aren't good. But at least with those cases, you can argue they got it wrong, right? It's not because of politics that they got it wrong. I don't know why they got it wrong, to be honest. It's quite strange to me. I think the sort of the zeitgeist at the time was just so anti-Zuma. The entire country, we had these big marches against Zuma, and I just think the tide was, they were just riding the momentum. But yeah, to this day, I don't know why they made that silly judgment.
Well, I think it's a good lesson, because even if your team is winning in terms of the outcome of that judgment, you might create unintended consequences in the system that might come back to bite you. And it's one of the criticisms of the Constitution itself, that it was designed for a Mandela, but what we got was a Jacob Zuma. And, I think another classic example of that is the appointment of the National Director of Public Prosecutions, who leads the National Prosecuting Authority. That's a presidential power. And during the Zuma years, he just appointed somebody who was
from the sheep.
Yeah.
Yes.
Exactly. So, you kind of need these checks and balances in the legal architecture, but I also think you need a political culture that values accountability, that stresses the importance of transparency. And that's what civil society organizations, such as the ones you represent, are so good at achieving. So Daniel, are you winning? Are you achieving what you are setting out to achieve? Do you think you're pushing back the tide against some of this state meddling?
Yeah, I mean, I guess the question is what is success, right? Or what are your goals and what do you want to achieve? I mean, for example, so I was involved in the, like you mentioned earlier, the Kill the Boer case, and again, I mean, that's a horrible case to lose, especially when with these type of cases, they're often difficult, and often, I always advise clients, litigation is 50-50, but often in public interest litigation, it's more like 40-60 in the favor of the state, right? You aren't on equal footing because just of the nature of the cases that you're bringing. But there are cases where you just know, this is going to be a tough case, and if we win, it's highly unlikely. But you sort of go in with that expectations. One of those cases was the Cuba case, right? The Cuba donation case. We from the start knew this was a difficult case, and I was a bit surprised when we were successful. I mean, we're obviously prepared to be successful, but you get a feeling, sitting there in court, listening to the arguments, listening to what the judge says, you get a feeling of which direction the case is going. And with the Malema case, I was really under the impression that we'll be successful, at least in the biggest part of what we were seeking. And I think perhaps I was blind because I just thought, the average South African, the ordinary South African, looks at or listens to what Malema says and thinks, well, this is despicable. So I was a bit surprised with that case. So, but now, so getting to your question about are we winning and are we being successful? I think the question, is what exactly do you want to achieve? I can give a good example of this, although I wasn't involved in the litigation itself at that point. But AfriForum were involved in a bunch of language cases at universities for a couple of years, basically starting here around 2010, 2011, where there was obviously a lot of pressure at universities. It's particularly the sort of traditional old Afrikaans universities, UP, the Northwest University, Stellenbosch, those places. Although at that point, UJ already completely, changed its language policy. So AfriForum was involved in a lot of these cases. And the point of the litigation at that point, they sort of knew that they're fighting a losing battle, right? In the end of the day, the universities are probably moving in the direction of just having one language of teaching and learning, being English. But the goal of the litigation was to stall that process as far as possible for two reasons. The one, to potentially create room for this not to just be a battle between Afrikaans and English, but for it to become a battle of mother tongue education where there are viable other languages at tertiary level where universities can actually adopt those as a language of teaching and learning, which we've now seen at, for example, the University of KwaZulu-Natal at UKZN. So that was the one goal. And then the second goal was for them is to buy more time to ensure that there are alternatives. And now, 10 years later, they've founded, or through their sort of sister organizations, we have academia, where Afrikaans is the language of teaching and learning. So in that sense, I mean, they lost a lot of those cases, right? They lost the case against the University of the Free State in part. They won the one against UNISA, coincidentally, but the Stellenbosch fight is sort of still ongoing. And I mean, you suffer a lot of defeats, but the goal isn't necessarily winning the court case. There's sort of a broader goal to achieve. And I think if you ask yourself that question, then I would definitely say yes. I think a lot of our clients are winning. I think they're achieving what they want to achieve. They are making South Africa a better place, and I think they are sort of state-proofing communities and individuals all over South Africa and protecting them. I think the decay would have been much faster had it not been for all these wonderful organizations, putting up a really formidable fight.
Yeah, and I think it's very important to engage in those court battles, but not to stake everything on those fights, right? So, like you say, you're busy building alternative structures, new community-based security initiatives, to prevent farm attacks, for example. But you're also saying, well, let's try and stop this hideously violent song from being sung as well. And so I think there's kind of multiple arrows in your quiver, and you use different ones for different purposes. I've often had the guys from Sakeliga on this show, and one of the strategies that they're also developing is alternative dispute resolution. Actually delinking that reliance on the public court system, and coming up with ways in which to settle commercial disputes. So I think that's also an interesting example of the state proofing, of insulating yourself away from some of these more damaging policies.
Yes. I mean, so I know Sakeliga's attorneys quite well, and they really are very shrewd and good litigators. They pick their battles very specifically, and they're very good when they take on those cases. I mean, they've had great success in the past couple of years. I mean, the Triple PFA case is a major win against sort of racialized employment in public procurement. But like you said, so on the side, they're doing all these other things. And what's interesting about that is, in a way, they're also, Sakeliga's catching a wave, because even before Sakeliga started pushing for this alternative dispute resolution platform of theirs, we started seeing commercial entities putting in arbitration clauses in their contracts because our courts got bogged down. The admin, they were getting behind on admin. So they started working that in. So you sort of see, people adapting. It's similar to how you now see, long-term lease agreements of property or land or farms containing clauses regarding EWC. Sort of in a way, the law does preempt what might come. And so the alternative dispute resolution really did sort of gain a lot of ground in the last 10 years, and we saw a lot of people rather going that route. And this actually, it ties into one of the points I thought we could perhaps potentially discuss, but it was sort of more suitable at the beginning of the conversation, but I think is a good point to raise it now, is a lot of public interest litigation is sort of inadvertent, right? It's not, it's not necessarily a big civil rights organization who goes to court. A lot of these issues sort of pop up through normal litigation. So, for example, there was a recent case in the Eastern Cape where Intercape bus services, these long distance bus services, they took the Minister of Police and Transport and the MECs for Transport and Police in the Eastern Cape to court, saying you can't keep our buses safe on your own roads, and you should be held accountable. Now, I mean, that's not a commercial dispute at all, but it is a private entity, deciding, screw this, we're going to push through this litigation, we're going to hold government accountable. Another interesting case that we are hopefully getting involved in quite soon is there's a farmer in Mpumalanga where he has labor tenants on his, or people who want to be labor tenants on his farm, and they've wanted to get various, labor tenant rights. And the Human Rights Commission did an investigation, and they also submitted a report. And they said to the farmer, well, this report is binding on you. And he said, well, no, the Human Rights Commission reports aren't binding. So they went to court regarding the functions and powers of the Human Rights Commission, similar to the Thuli Madonsela case. So here you just, have an average Joe farmer in Mpumalanga, in the Mpumalanga High Court, fighting this very important constitutional question. So a lot of public interest litigation, doesn't really start out as public interest litigation. It's not the purpose of it. And nor are they sort of, they're not these heroes with their capes on already. They sort of only get their capes later on and sort of unexpectedly. So yeah, and I think this, it gets back to the point you made earlier about alternative dispute resolution. A lot of these issues of sort of state proofing happened without, the active push for it to happen. It's the same as businesses becoming self-reliant, getting their own power, getting their own water, getting their own security services. And I mean, that's good. That's what you want to see. You want to see people being proactive and solving issues in their communities and in their sort of direct areas where they're involved in.
So Danil, as we bring this conversation to a close, I would like to give you the opportunity to speak to that ordinary Joe who might be listening to this show and convey the importance of the law as an instrument for social change, because I think many people perhaps a bit despondent about where South Africa is at the moment, but there is power that individuals can exercise.
Yes, I mean, it's true, and litigation is expensive, right? That's usually people's first sort of experience with the laws. They're like, well, they can't afford this. But firstly, I'd say, well, there are a lot of organizations that are willing to help. They can't obviously help with every single small dispute that doesn't have a broader issue at heart, but they can help with a lot of these things, particularly if you're really a marginalized party being affected by state decisions. There are a lot of organizations, wonderful organizations all over the political spectrum who can assist you with that legal, the legal issues. But then also a lot of these issues can be solved sort of outside of court, right? I mean, I always encourage people, participate in public participation campaigns, let your voice be heard, hassle your local councillor, your ward councillor, make noise, write emails, get involved, right? It's these issues aren't just going to be solved by, sitting back and waiting for, the big civil rights organizations to do it. If you have an issue in your street, tackle it. I really think we need to learn to that because for a long time, I think people thought the state's going to solve my problems. And I think we're getting to a point now where people are thinking, well, civil society is going to solve my problems. But in truth, you are supposed to be the first person trying to solve your problems, even if they are massive. Take hands with your community, take hands with your neighbors, and try and solve those issues. And yeah, I mean, that's really the best way to try and build a better South Africa, I'd say.
Danil Eloff, thank you very much for joining me on the Solutions podcast.
Always a pleasure, David.
If you enjoyed this conversation and you're watching on YouTube and you'd like to support this podcast, the best way you can do so is by hitting that like button and also subscribing to the channel. So if you enjoy this content, please do that. If you're listening on your preferred podcast platform, please do subscribe there as well. My name is David Ansara. This is the Solutions Podcast. Until next time, take care.